Okay. Hi, everyone. Welcome to the lecture video for criminal law. As I said in my intro video, this is how the class is going to work. I will record lecture videos of the important notes, which are part of the readings. And yeah, I'm going to say right now, no matter how long this video is, I urge you to take your time. You do not need to watch it all in one sitting. Take your time. Pick up where you left off. I make one big video with all the content, and then you can watch it as much as you need. That's the beauty of it. So, welcome to Criminal Law. This is our first lecture. So, very specifically, we need to talk a little bit about civil law versus criminal law. And the important piece here is where they're different. So, civil law, if we wanted a textbook definition, is the body of law having to do with the private rights of individuals. Their goal, their job, is to provide remedies for individuals who need to enforce private rights against others. If you've ever seen anything like Judge Judy, Judge Joe Brown, Judge, I think Alex Jones, or not Alex Jones. Alex Jones is a very different person. But if you've seen any of those types of shows, those are all civil cases. They're private matters and disputes between individuals. Civil law deals with that kind of thing. They have terms like torts and litigation, which they're very fun to talk about. They're very interesting. But for our purposes here, that's not what we're focused on. We're focused on criminal law, where civil law is private people, things like defamation, divorce, things like that. Criminal law is the body of law having to do with violations of order to society. The point is the wrongs that we do, that we have some kind of law that says, nope, you're not allowed to do it. So criminal law seeks to punish an individual for actions against the government or society at large. And what I do want to say here is that while they have the same courts, and I put that in quotes, they might have different exact courtrooms and different judges, but they use the same basic structure and the same basic system. But while they are the same in that sense, they have different goals, purposes, and results. So obviously, there needs to be some kind of identification of how they are different. And we'll talk about that, but in a same sense of where they're similar, we also need to talk about how there's a defendant, the defense. But there's also a plaintiff in civil law, but in criminal law, it is oh my gosh, I'm drawing a blank on the term right now. The prosecution. I got it. But while civil litigation's main goal is to provide liability and compensate appropriately, criminal prosecution, criminal law, is looking for that liability, but now to punish appropriately. And when we talk about punishment, we need to understand that there are, in general, 4 theories of punishment. And yes, this will come back up again in this lecture, but it will also come up later in the class. And so, the 4 general theories of punishment are retribution, incapacitation, deterrence, and rehabilitation. I always say you know your theories of punishment by looking at your RIDR, R-I-D-R. Retribution, incapacitation, deterrence, and rehabilitation. Now, those are the big fancy words. What they mean are in my parentheses underneath. So retribution is the classic idea of punishment. There are things like an eye for an eye. There are things like you made this issue, you took this thing, we're going to punish you for that. The idea is that the punishment fits the crime. Our second theory of punishment is incapacitation, which is holding. So for our purposes and understanding, when we talk about incapacitation, we mean jails and prisons and institutions like that. They are literally holding people out of society. We are incapacitating them so they no longer commit crimes. Deterrence is the idea of stopping crime. And typically, deterrence is having a harsh punishment, like heavy fines or long jail times, in an effort to deter or push away from criminal behavior. And then our last form is rehabilitation, which is reform. The concept here is that criminal behavior is not a normal action. There are motivations for it, and if we can identify the problems that lead to it, we can solve it. We can make it not an issue. So those are the 4 general theories of punishment, and like I said, they will come up. They will come up throughout this class because how punishment works is related to the crime, and we're going to see that here in just a few moments. All right, so realistically, we should probably address what is crime? What is a crime? And I know that if I asked anyone, hey, could you tell me what is a crime? Most people would probably give me an example like arson, murder, assault. Okay, you're right, those are all crimes. But what is a crime? And so, in a kind of textbook definition, a crime is an act committed in violation of a law prohibiting it, or omitted in violation of a law ordering it. In simple terms, a crime is an action that you do when there is a law that says you can't do it, or where you don't act when a law says you have to act. That's what a crime is. And what's important here is that that's just a textbook definition. I'll tell you right now, I am not looking for that answer ever. I'm not looking to see you write out that exact phrasing, because we all understand that crimes are complicated. They're not straightforward. We know that they're a wrong, but it gets a little messy. And so it's important to note that all crimes have certain elements, and those of you who have taken Intro to Criminal Justice already might be familiar with the concept of the elements of crime. And that's the general idea that there are 3 elements to any crime, and that's the criminal act, the criminal intent, and a concurrence of the 2, which means they happen around the same time-ish. But the reality is that's not all the elements of crime. We're going to talk about way more of them throughout the semester. We're going to talk more about the concepts of crime. We're going to look at different types of crimes, but for our purposes, what's important to note and why this is what we call foundational, because it's the part that helps lead us into the conversation of what is criminal law, is we have to understand that all crimes have intent and have an action. And another quality or another element of crime is something that's required for the act, and that is illegality. The action itself has to be illegal for it to be a crime. If it's just a suggestion, it's not illegal. You don't have to follow it. But if it's a law, now you have to. And so, very specific, well, not very specifically, but generally, the government must enact or create a criminal law specifying the crime and its elements before it can punish someone for the act. And I hear you going, well, what about when somebody does something for the very first time? And you're right. Then we have a different case. But in general, what we do is we create laws saying what is and is not legal, and then we charge someone. There are cases where brand new crimes happen, and they're the ones that set the standard for how laws go forward. But the idea here is that an action has to be illegal in the first place before you can charge someone with it. So, in the United States, we do have a process for determining what is and is not illegal. It's the same process that we have for determining what is and is not a law. And I want to say very briefly, this is a very, very, very broad overview of the cycle. We'll talk about a couple of the parts of it today, but it'll come back up. In the United States, when an action occurs that leads to an issue that would become a law, once that happens, it ends up falling on a person or a group of people to suggest change or action. Civil rights didn't happen in a vacuum. Marriage equality in general did not happen in a vacuum. People saw issues with what was going on. They gathered together, they suggested change, they demanded action, and then government officials noticed it and started to suggest the change. At the lower local and state levels, the public voted on it. And when it got to the federal level, the government voted on what is and is not constitutional and what is laws, and that becomes a law itself. And that's an important piece and why I have it in italics and with an asterisk. The public votes on it. That's the power of democracy. That is the power of the way that our country typically operates, is that the general public is the one who has the voice in what is and is not the law. If we disagree with how something is, we work together, we band together, we get the idea, and we bring it forward. We make our voice known. Now, this is the part that's important to remember. Changing a law does not happen overnight. It's not a simple, I want to see it changed in 6 months. It takes years. The process itself is long and complicated. So, remember that, and that's why I say to every student, every semester, I've been saying it the last few semesters, but it's still relevant now. Watch what's happening around the country right now. Pay attention to the new rules, the new laws, the, what are the executive orders that the president puts out? All of those things are not necessarily laws, but they're things that push towards laws. That's how we can see things happen in real time. So pay attention to those things. All right. In general, kind of backing back out a little bit, here in the United States, we have a dual federalist system. What that means is that we have a federal government and several 50 state governments. They're all equal. They all kind of deal with the same stuff, but in different levels. And the federal government is uniform across the country. Everybody has to follow the same federal laws. The federal laws are things like the Constitution. They're things like sweeping Supreme Court decisions that impact how things can and cannot operate. They're all of those sorts of things. State laws, on the other hand, they vary from place to place. So what passes for law in Alabama may not pass as law here in Pennsylvania. What passes for law in Florida might not pass as law in California. That's the idea, is that the state laws are able to vary from place to place so that they all are dealing with their own issues, but as long as they do not go against what the federal law says, then they're okay. And we're going to talk about that in a bit. But because we're a democracy, and as I said, we were going to come back to it, people have a say in what passes as law. Because everybody involved in it, even in government, they're all still people. As a result, our laws are inspired by a lot of different things. A lot of times, and it's uncomfortable to think about, but our laws are oftentimes inspired by people's personal religion, their culture, their history, their beliefs, their backgrounds, their biases, their value systems. This is not the full list. This is just a general idea to get up to the point that our laws come from a place of our beliefs. They come from a personal spot. If you want to see change, you're going to have to push it forward. You're going to have to think about it. You're going to have to consider it. But also be aware that sometimes these things play a role in how people decide choices. If you want a good real-world example of this very thing, You can look at culture and religion and value systems, as well as biases, and fold those all together and have the discussion of Roe v. Wade and Dobbs. The decision of the Supreme Court to previously allow for abortions being a protected part of women's rights, and then being overturned in 2022 to being a state's rights, so all states could do their own thing. This is something that we see the culture changed around it. We saw the inspirations of particular religious groups and value systems that held those beliefs about it. So we see this happen in real time. This is not something that is a vacuum. It's a real thing that happens over time. And that is the best example to segue into the statement that laws are not static. Laws change over time. They're meant to evolve and adapt. Now, not every decision and change is right, but they are meant to be able to adapt. Another example is the Second Amendment, the constitutional right to own a weapon. The right to bear arms is a constitutional right. The historical context, when it happened, we were at the beginning stages of our government. We did not exist as a full country yet. We were 13 colonies. And so we needed to establish that as a country, we need to be able to have armed men that can form a militia to stand up and protect our home. Now, also the weapons they were using were mostly, muskets, shotguns, and some early pistols. That was the standard. Now, jump ahead to, 2010. Do we need a militia in 2010, or do we have a fairly large military that handles the security of our homeland? We have a military. Has weapons changed since 2000, or weapons have changed since 2010, but have weapons changed since the 1700s? Yes. Does that mean that you're not supposed to own any weapon at all? No, the constitutional right is still there. We just now understand that it evolved a little bit. We adapted our understanding. You're allowed to own a weapon for self-defense. That was the point of the militia thing. But now we don't need the requirement of a military force. We just need self-defense. And we understand that weaponry has changed. The right to bear arms, does that mean that I can only own a 1700s gun? No, that thing, if it's well kept, will be fine. But if it's not, it's likely to blow up on you. Can you own most type of weaponry that's not heavily regulated? Yes. You can own a lot of, or not regulated, but, I forget the term that I want to use for that now. But the idea is, it is intentionally designed to adapt to modern times. And so despite what many people believe, law and criminal justice as a whole is not black and white. It's millions of shades of gray. And I know for some people that's absolutely frustrating and baffling, and I get that. But it's important to note that it is not black and white. The way law is written is supposed to be black and white, but there's exceptions, there's rules that have to be followed, there's rules that can be followed but don't have to be. It is meant to be ambiguous because not all situations fit perfectly into the same box. You have to have ways to vary that and make it work. So, it's important to understand that it is not a unchanging thing. It's meant to adapt with us as we go on. And law and procedure is not the same. Law establishes what is and is not. And procedure is how it's implemented, how it works. We have a right, a constitutional right called the right of due process. It means that we have the procedure, how things need to be, or we have a law that says what we are and are not allowed. Due process says everyone follows the same guidelines. Everybody gets the same rights. How it looks, how you get representation, that's a little bit different. That's the procedure. It's how it's implemented, not the law of saying you get representation. All right, so classification of crimes. What is important and necessary for your understanding as students in my class is that how we group crimes is often based on seriousness. And so we classify crimes in a lot of different ways. We categorize them, we define them differently, we grade crimes. We do all these different things, and I'm going to be honest with you. The main reason we do this is for ease. When we have so many laws, and we have a lot of laws, you want to be able to have quick and easy ways to identify things so that you don't have to always look into every tiny little detail. You can have general ideas to combine them together. So, one way we classify crimes is simply through the target. So we have things like bodily crime and property crime, and they depend on, again, the target. Bodily crimes are things like assault. They're things like, oh my gosh, I forgot murder for a second. My brain just went blank, but bodily crimes are things that involve the physical body. Assault, battery, fighting, murder. That's all bodily crime. Property crime deals with property things. So things like burglary, arson, theft, typically tend to be property crimes. So that's one way we can classify them is by the target, but we can also classify them by their grade. And when we grade crime, we're giving it a level of importance. And so you'll see we have 4 here, but there's really only 3 that are important. It's felonies, misdemeanors, and infractions or violations. So I'm going to address the felony misdemeanor one first, just so that we understand why it is the way it is. So felony misdemeanors are fluid, and what I mean is in the sense that they can be changed as either a felony or a misdemeanor, determined by a judge. And oftentimes it's particular factors of a case. It can also be jurisdiction that will change the classification or the grading of that crime. So let's talk about the other ones. So typically when I say what's a felony, most people will identify that it's a serious crime. And you're right, that is the actual answer. A felony is a serious crime. They're the high serious crimes, the most serious crimes. They're things that are open to all sentencing and punishment options. Felonies are the things that are open to the death penalty. There are also things that are open to life in prison or short-term prison sentences or even, some fines and some community service. Technically anything. I don't often see, you really don't see felonies getting it, but they are technically open to those. But felonies are the serious things. They're the things like arson. They're the things like assault. They're the things like murder. One way to kind of put together that bodily and property crime in with felony is most crimes that are classified as felonies involve violence. Violence tends to push crimes towards the felony side. Misdemeanors, on the other hand, are less serious crimes and are usually punished with jail time, not usually prison, but they can be. Now, going to an example of property crime that could be a felony or a misdemeanor, depending on the situation, is theft. Theft can be a misdemeanor if it's a low quantity, low value, and no weapon or violence was used. You just stole it. Could be a misdemeanor. Stealing a lot of money or a lot of value worth, or using a weapon or a threat of violence to get your goods that you are stealing would be aggravated theft, which then would upgrade it from a misdemeanor to possibly a felony misdemeanor or a felony, depending on the circumstances. That's why I said it really is important to understand. Misdemeanors are not unserious crimes, they're just less serious than the felonies. And then infractions or violations, they really are the least serious. When we say infractions or violations, we're talking about things like jaywalking, running a red light, things like that. They're usually you're charged with fines, not really jail time. You can, but it's typically not the focus there. So another thing with the classification of crimes is we also know that intent can impact the level. The intent that an individual has can impact the grade level of a crime as well. And when we talk about specifically types of crime, another way we can classify them is understanding malum in se and malum prohibitum. And anyone who's had me before knows I love the Latin words. It's always fun to learn a little bit new. So malum in se is evils because they are, or wrongs because of themselves, whereas malum prohibitum is wrongs because we say so. So a good way to explain this is malum in se is a crime that's a crime because we know it's a crime. Stealing is a crime that's wrong because we know it's wrong. Murder is a crime that we know is wrong because it's wrong. Those are things that we universally agree with. Don't steal, don't kill, things like that. Malum prohibita, though, or malum prohibitum, is wrongs because society says they're wrong. So thinking about the extra readings I provided to you, the weird laws of different states and everything, a lot of those are silly. And a lot of them are meant to be silly because they were from a different era where we had different beliefs and ideas, but they were also usually malum prohibitum, things that were wrong because the general society felt that they were wrong at the time. So one of my favorite examples that I always tell people is public nudity. Public nudity in the United States is malum prohibitum in most places. You are not allowed to be publicly naked. Why? Because society said it's wrong. So you can't get naked, run out in the middle of the street, and not get in trouble for it here in the United States. Now, in other places, there's different laws that don't say nudity is inherently wrong. That's malum prohibitum. They're wrong because we said they are. So I'm going to emphasize that this is a very brief overview of jails and prisons because this is criminal law. We're focused on the law part, not the punishment side. We're going to talk about punishments throughout, but jails and prisons, if you really want to get into the nitty-gritty of them, take Intro to Corrections. We talk about that there. But for our purposes, the very brief breakdown that you need to know the difference is jails are run locally and prisons are run by either the state or the federal government. Jails are meant to hold people temporarily, often waiting trial or as part of a lesser punishment. Prisons hold people for longer periods of time. They tend to have different programs involved, but also their restrictions are higher than at a jail. It's not to say jail, you're free to do whatever you want, but it's a lot more free than prison. And the more serious crimes are the ones that are held in prison. You would not see a murderer held in jail outside of waiting their trial. And even then, it would be under pretty close watch. All right, so let's talk about punishment. And if you remember, I said there's the 4 theories of punishment. It's going to come back. It's coming back here, but this is not the last time you're going to see it. We're going to talk about it more and more. So punishment as a term, we're referring to the end result of being found guilty of a crime. And realistically, while we have the 4 theories of punishment, those 4 theories are also part of the recognized purposes of punishment. That's hence why they're theories. So for punishment, we understand retribution. The purpose is to punish someone physically. Incapacitation is to literally hold somebody against their will so that they cannot continue to cause problems. Deterrence, going to, and discussing about specific or general deterrence. What you need to know is that specific deterrence, where you target the particular crime and try to address the underlying issues, works, but general deterrence does not have a strong success rate in the data. But what's important is deterrence is meant to stop an individual from committing a future crime or continuing to commit a crime. Rehabilitation, the purpose of the punishment is to lower recidivism rates, which is the rate of reoffending. And they do that through different measures, whether that be education, therapy, mental health, whatever it might be. But the fifth recognized purpose is restitution. It's why I said the 4 theories of punishment are here, but there's one more, and that's restitution. And that's where we punish financially. And very specifically, the idea of restitution, not only are you punishing somebody financially for their issue, but you're also paying back the victim. That's what restitution's all about, is paying the victim back a monetary sum for the crime that was committed. So, what I want to wrap up with is talking about the sources of law. And I want to emphasize the 3 sources of law we're going to talk about are not the only sources of law, but they're the 3 big sources of law here in the United States in particular. So, the first one is constitutional law, which is exactly what it sounds like. It's the U.S. Constitution. I do also want to note here that individual states have their own state constitutions. That's something that not everybody has learned or knows, so I like to bring that up so that, you know, it's a fun fact. You learn a little something new, even if you already knew most of this stuff. So very specifically with constitutional law, the role or the job of the Constitution in all the state constitutions are to regulate government action. And that's an important piece that a lot of people tend to forget. Constitutional rights aren't rights that protect you from other private citizens. They're things that protect you from the government. Constitutional law is saying the government cannot decide these things about your life. The right to bear arms, the constitutional right, means that the government cannot come in and take your right to protect yourself with a weapon. The First Amendment, the freedom of speech, says that the government cannot come in and tell you what you can and cannot say. The Fifth Amendment literally says the government cannot make you self-incriminate yourself for a crime that you may or may not have committed. The Eighth Amendment, which I believe is the due process one, is the one that says the government can't deny you the right to an attorney, the right to have government representation, the right to have your case heard by a judge and a jury if you're so choosing. There are things that protect you from the government's decisions. Now, this is the highest source of law, and at the lower levels even, they cannot go against constitutional rights. So even if the Constitution is meant to be about government regulation, the other laws that are things private citizens have to follow, they can't go against what is a constitutional right. That's part of how this works. Now, I will say this, and we will talk about it later in the class. There are exceptions to constitutional rights that we will get into. Specifically, we'll talk about free speech and expression because it's an important thing to talk about, especially with some things that have happened recently in our nation. Now, the second source of law that we're going to talk about is statutory law. And statutory law is, the whole point is to regulate individual or private action. So if constitutional law focuses on the government, this is the stuff that focuses on you and me, the us part. And real quick, a statute is a written and published law, often put in some sort of penal code, which is a list of laws. These are things that had to have been approved of by some person. Remember how we said the process has to do with like voting and talking? Yeah, this is statutory law. They're the things that are written down. They're the things that somebody says, hey, did you know that there's a law that says that you are not allowed to do this particular action? Those are statutory law. They're the things that are written down that say you cannot do this. So, they cannot conflict with or supersede, which means go above and beyond what the constitutional rights are established. Within statutory law, there are a subgroup called administrative laws and ordinances. There's special type of statutory laws that we're not going to get into too much right now, but it's important to just kind of get a general idea. Administrative laws are special laws that are by agencies, things like the FDA, Food and Drug Administration, the EPA, Environmental Protection Agency, the IRS, the Internal Revenue Services. They have rules that have to be followed by everyday people, but they're also in charge of enforcing those rules. So they're different, but they are statutory law. They're a little bit different. And then ordinances they can be administrative ordinances, but they can also be local ordinances, like jaywalking, or very specifically in Erie City, which is an interesting one, is open container policy. In Erie City proper, it is okay to walk around with an open liquor container. You cannot drive with an open liquor container, but you can walk around the town with an open liquor container. In other places, you cannot. Before we move on to case law, there is one thing I want to say about penal codes, and that is there is a model penal code in the 1960s. Some legal scholars, lawyers, and judges came together. They looked at a bunch of different penal codes from around the country, and they suggested a standard set of statutes that everyone would follow. Not every state took it, but a majority did. Majority of the states still use the model penal code today. Others took parts of it, and some of them just kind of said, no, we're doing our own thing. PA is one that does use the model penal code as its like base. So it's just important to note that it's not an break or a make or break type of information. It's just an interesting fact. And then our third one is case law. And there's a reason that case law gets its own slide, and that's because it's actually what we're going to be talking about and what we're going to be looking at. So, and I don't mean that we're not going to look at statutes or constitutional law. We're going to look at both of those things. But case law is relevant to an assignment, and that's why we're talking about it. So, case law is rulings on the facts by judges. In other words, it's the laws that are made by judges. And if you're like, I didn't know judges make laws, it's because they don't make a law, but they enforce, or they make judgments based on laws, how they work. And so there's this power that is called stare decisis. And all that really means is that it's about setting precedents, setting established rules of how things should be done. The idea is it's not that you have, this is the law you have to follow. It's more of saying, hey, when I had this case with this type of information, this is what I did. And it seemed to work out pretty well, so let's continue doing that. That's what setting a precedence does. And it's important to note that a lot of case law, a lot of what we know as how courts proceed and how those things work are based on this. The origins of case law comes from English common law, and that's let me give you the 30-second history. Majority of criminal justice around the world has origins and history in British English systems because they owned most of the world at one point. So we have a lot of things in common, and English common law is the origins of what we have in case law. English common law was just basically a bunch of, a certain individual, William Blackstone, looked at all the different judge decisions and said, hey, I should probably write down what people have said so that we can kind of get an idea of these are the basic rules that we should follow. That's what it was. And so it's not what was written, but what was previously done. And it took into consideration things like tradition and local customs. We don't really follow English common law. Some places still use common law, but common law has morphed and evolved. And that's become judicial review. That's the modern case law and the modern common law. Very specifically, judges interpret the Constitution and statutes in a particular and fair way. And what I mean by that is they look at the Constitution, they look at the way laws are written, and they determine the most appropriate, fair way to read it. And that helps determine whether or not somebody is innocent or guilty. It also helps determine how cases can go forward, how swiftly, how complicated, all of those things. So, why does this have its own slide? Well, it's because of the last two things on here. So if you remember, I said this first week, there's not going to be a case study response, despite the fact that I talk about it there. This is my little talk about it now. Next week, we will do an entire little video talking just about the case study responses. The reason why I'm saying it today is case studies are traditionally very detailed presentations on how a client won their lawsuit, including first-hand accounts by legal students or early lawyers. Case studies are in-depth and super complicated. You are not writing super in-depth. You are writing modified case studies. We will go over it in its own video. But they're closely related to case law, because case studies are how lawyers learn how to do this. And so in this class, one of the things that we're going to be looking at, pretty much all of our case study responses are looking at what's called judicial opinions. And judicial opinions are judges, specifically appeal judges, looking at the cases from a lower court where somebody already went through, and what they're doing is they're doing just this. They're making case law. They're saying, hey, based on the decisions of these previous past lawsuits and these other cases and the evidence that was brought forward, we either agree or disagree with this idea. That's what we're looking at as judicial opinions, the opinion of judges who looked at this and made a call. So we will talk more in depth about these in the video going over case studies. That takes us to the end of the lecture. I thank you all for listening. Like I said, please take your time through this. Don't feel like you have to rush through the video, because if there's something you weren't sure on, go back, listen to it again. If you have questions, reach out to me, send me an email. Now, outside of the case study response, the big assignment that's due at the end of the semester, the building a case assignment, remember, I will be posting a short video going over that assignment later this week. So be on the lookout for that. I will make an announcement when I post it. Thank you very much. I hope you have a wonderful day, and I'll see you in the next video.